Okay, if council are ready, we'll call the case, which is case number 62528, Villa Palms Court 102 Trust versus William L. Riley et al. Respondents. We have Mr. Infuso representing the appellant, Ms. Schuler-Heinz representing the respondents. I also see other counsel there. Mr. Joe, are you involved in the case to argue, or? I understand. Okay. Very well. Thank you. Okay, we'll go ahead and proceed. Mr. Infuso, would you wish to reserve any time for rebuttal?
Yes, Your Honor, 4 minutes, please.
You may proceed.
May it please the Court, Michael Infuso and Zachary Takis on behalf of Appellant Villa Palms. This is an appeal from the District Court's denial of our application for preliminary injunction. The action arises out of a quiet title action Villa Palms filed after it purchased property in an HOA foreclosure sale conducted pursuant to NRS Chapter 116. Simultaneously with the filing of the complaint, Villa Palms sought a preliminary injunction to stop Deutsche Bank from foreclosing on the subject property. The District Court did determine that the HOA foreclosed on a super priority lien, but it determined as a matter of law that the foreclosure of that super priority lien did not impact or extinguish Deutsche's first deed trust. Since the District Court's determination was based upon the interpretation of Chapter 116, it's a question of law that should be reviewed de novo. The issues before the Court are really twofold. Does an HOA have a lien for assessments that has priority over first deeds of trust? And if so, how does it have to be enforced? Now, before we get to the language of the statute, I want to put this issue in context. HOAs serve a very important function. They provide public services. They maintain roads, parks, recreational facilities, landscaping. This maintains the property values, and those expenses are passed through to the homeowners. In the state of Nevada, there's about 3,000 HOAs, of which there's 5,000 units in those HOAs. So, roughly, approximately half of Nevadans live in HOAs. Now, Deutsche would like to characterize this issue and focus it on the third-party purchasers. But that's not what's at issue here. The third-party purchasers don't get involved until the application of the law and the issues that are at hand in this case. They just show up and bid on the property. That's it. What is really at hand, this is an issue between Nevada homeowners and banks. If HOAs don't have a guaranteed method of collecting their lifeblood, the assessments, the HOAs are going to either have to stop providing those public services, which will result in a depreciation of more values, or the homeowners will have to pay even more.
I think, Mr. Infuso, I know the oral arguments in this case and the next case, I know that we have two main issues. I know in the interest of time we really want to focus on, because we probably have 100 cases pending in the Supreme Court on these.
I just wanted to put in context. Let's turn to the plain language of the statute. The question is, does it have a real meaning? The starting place is Chapter 116, Section 116.3116. And this reads, the association has a lien on a unit for, among other things, assessments levied against the unit. The term lien is used 28 times in 116.3116. Overlay that with NRS 116.1108, which specifically provides that principles of law and equity, including the law of real property, supplement the provisions of Chapter 116. And lien means lien. As this Court decided in Ham v. Arrow Creek Homeowners Association, define the term lien as a lien is a security device that binds the property to a debt. That's what a lien is. Nothing in 116 or anywhere else that supports another conclusion. So the question is, what's the priority of this? And that's in subsection 2, which starts, a lien under this section is prior to all other liens and encumbrances on a unit. That's the rule. It's prior to everything. Except 3. There's 3 exceptions. One that's applicable is 2B, which provides first security interest on a unit recorded before the date on which the assessment sought to be enforced became delinquent. That's where the bank's analysis stops. But you got to go on the flush language, which is really not an exception to the exception. It limits 2B exception. And that provides that the lien is also prior to all security interests described in subparagraph B for security interest to the extent of maintenance and abatement costs and 9 months worth of assessments immediately preceding the institution of an action. Prior to, there's only one definition before priority. It has priority over first security interest. And this makes perfect sense.
Is it limited to 9 months, though, as far as the, assuming we agreed with you that it has priority over the first trustee, is it limited to 9 months?
It is limited to 9 months.
Okay.
Has to be. That's the equitable balance that was struck in the Uniform Act that Nevada adopted. It's limited to 9 months. But it doesn't matter if the HOA forecloses on it. It's a true priority lien. It still wipes out junior interest, including first security interest.
Okay, well, let me jump to this issue, too, because I think you just did it now. I think the most critical issue here today is the definition of the word action, i.e., can you have a private foreclosure on a homeowners association lien, or is a judicial foreclosure required, which I might add might implicate a right of redemption for 1 year under the judicial foreclosure with the statute. So what's your thoughts on that?
Sure. Well, again, we start with the basic principle, NRS 116.114, which provides that remedies provided in this chapter must be liberally construed. The argument that you must file a lawsuit derives from one word only, and that's an action. But to put that word in context, you got to look at the organization.
Well, it's more than one word. It is institution of an action to enforce the lien. Institution of action, to me, signifies judicial action. Theoretically.
And I understand, Your Honor, and I'll get to that a little bit more. What if we focus in on the word institution of an action, because you could say institution
One
of
phrase, you can do a phrase, but I think you have to take institution and action together.
Sure. And I understand. Because you could also say institution of proceedings. That wouldn't mean a lawsuit necessarily. So I think the phrase institution of an action, really the key word in there is action, but I understand your point. But look at the organizational structure of 116. Subsection 1 in 116.3116 is the creation of the lien. Subsection 2 is the priority of the lien. And then NRS 116.3.31162 through 31168 are the detailed enforcement provisions of how to enforce this. They're so detailed it talks about lot size. Nowhere in those provisions does it make any reference to judicial action.
Well, let me ask you this, Counsel. In private foreclosures for association liens, generally we're thinking of private foreclosures for deeds of trust, and with those you give notice to everybody that's filed requests for special notice, or maybe has exception to marketable titles, so people know before the trustee's sale is held, at least 111 days it takes under the deed of trust to hold the foreclosure. Here, how do we know that all the people have the interest in the property? That is, it could be banks, maybe somebody with a list pendants, maybe somebody with a tax lien. I mean, there's all sorts of issues here. Have proper notice that their interest is going to be eliminated through the priority of the homeowners association lien. How can we assure fairness in that area?
Well, we ensure fairness by striking this equitable balance, limiting the priority to only 9 months. But the issue is, well, how can a wipeout occur if they didn't get notices? What I understand your question. Well, they get notice. NRS 116.31168, subsection 1, states that the provisions of NRS 107.090 apply to the foreclosure of the association's lien as if a deed of trust were being foreclosed. 107.090 in turn requires notices to subordinate lien holders. That's the first layer of protection of security parties that hold junior liens. The second layer is that anybody that has an interest in the property, must notify the association of its interest. It's obligated to do so. And in turn, that imposes an obligation upon the HOA to notify that party.
Well, when the private foreclosure is done by the HOA, what entity gives the notice to all the people that have an exception to marketable title? How is that done?
Practically speaking, Your Honor, is no discovery was conducted in this case, so we did not get to that issue because this was in the infancy. But practically speaking, the HOA hires a collection company that obtains a title report and will serve all those parties that have recorded interest.
So it's not done by a title company, it's done by a collection company.
The title company is not the one, as I understand it, the title company is not the one that serves the notice, although a title company is involved because typically these collection companies obtain a title report.
But they don't admit it. Title companies are used to doing foreclosures, and they do on deeds of trust. The question is, do these collection companies follow proper procedures here to make sure notice is given to anybody that has an interest in the property?
Yes, and there's no claim in this case that they didn't receive proper notice, and I've handled hundreds of these cases, and they always, because you have to serve it certified, there's always certified receipt. They go through this process. They're in the business of doing it like title companies. So there could be exceptions, just like a title company. But I don't think that there's any sort of intentional not sending notices or anything of that nature.
Well, the reason I ask is we've received dozens and dozens of written requests for many times lenders which say that they never got notice of the private foreclosure action, and the foreclosure's been held and they're left holding the bag, and they didn't know that they had to come in and redeem this property before it was too late. So it kind of puts us on notice that maybe this is a problem here.
But if it is a problem, it needs to be addressed on a case-by-case basis, not an interpretation that doesn't force the language and intent of Chapter 116.
But your argument, counsel, is notice is furnished in two ways under the requirements of 107-090. Notice is provided within 10 days of the notice of default awarded lien interest. And secondly, if a 30-day notice has been given under 1163, you'll also give notice under that statute.
That's correct, and there's a third layer. The secured party can specifically request notice. Now, whether you deem that to be an actual written request or the fact that using the recording statutes, Chapter 111 is constructive notice to all parties of its existence. The fact is, a lender, a secured party, can take efforts to ensure it receives notice by specifically requesting.
Does the record in this case show that the notices in any of those three forms were given to the lender in this case?
As I indicated, no discovery had been conducted. We filed an application for preliminary injunction at the very beginning of the lawsuit. The day we filed the lawsuit. In opposition to the application, the lender did not contend in any way that it didn't receive notice. And nor does it contend that it didn't receive notice on this appeal. It does make some general references that, well, they may not get notice, but they never come out and say, we didn't get it.
So there's no claim of deficient notice in this case, in the Twin Palms case?
Not as of right now.
And it wasn't raised in the district court?
It was not raised in the district court, Your Honor.
Nor was there any allegation made that there was a deficiency in notice because of due process?
That's correct. I'd like to turn back to action. There's institution of an action. The term action is used about 100 times in Chapter 116, clearly in contexts where it doesn't mean a lawsuit. There's also many examples in Chapter 116 where it clearly does require a lawsuit. Such terms as litigation in 116.2119. In 116.21175, the references may file a petition with the district court. In 116.2124, there's reference to commence an action in the district court. None of those qualifiers are in NRS 116.6.2. Looking at the other provisions in Chapter 116 support this conclusion that no lawsuits required. provision 116.31168. It says to foreclose on an HOA lien as if you're foreclosing on a deed of trust. Deed of trust can be foreclosed non-judicially. And so too can an HOA lien. Another important example is in NRS 116.3116, subsection 6.
Let's discuss that. Is it incorporating provisions for the foreclosure of the deed of trust only as to 17090, or does that mean that all other procedural requirements for non-judicial foreclosure of that deed of trust must also be satisfied, which would include other notices for sale, as an example. It would also include other special time periods that are incorporated. Should it incorporate the deed of trust foreclosure statute, which would set forth a whole separate series of procedural obligations that aren't embodied explicitly in 116?
Is incorporating the notice provisions to ensure that subordinate interest holders receive notice. That's it.
Which ones? All of them in 107? Only those in 107?
Those ones that specifically say they're simple. Ones that say that the notice must be provided to subordinate interest holders, and that's it. Because there's specific provisions in Chapter 116 that address notice in other contexts prior to homeowners and others. So it's only with respect to making sure, as 107 does, to ensure that subordinate interest holders have an
Let's
opportunity.
test this theory. Under 116.31168, language says the provisions, not the notices, the provisions of 107.090 apply to the foreclosure of the association's lien as if a deed of trust were being foreclosed. I'm just trying to figure out how much of the deed of trust foreclosure process is incorporated into that language and that provision. And you say it should be limited only to the notice expected to call under 107.090.3.
Well, let me clarify. 107.090 offers, and I'm looking at subsection 3, that talks about who gets notice and subordinate interest holders. There's also notice provisions of anyone who can make a request to receive notice, which is also in Chapter 116. Chapter 116 largely mirrors the notice provisions in 107, with the exception of incorporating in 107.090 to make sure that subordinate interest holders receive it. So, by referencing provisions of 107.090, the intent is to incorporate 107.090 in its entirety to the extent to make sure that everyone who has an interest in the property gets notice.
Council, I know we asked a lot of questions, and I apologize for taking your time. We'll give you 3 additional minutes here in rebuttal. Right, and then we'll add 3 minutes of time to the respondents. So,
Thank you, Your Honor.
Ms. Schuler-Hines, if you want to proceed on behalf of the respondents.
Thank you, Your Honor. Chief Justice, Justices, good afternoon. May it please the Court. Today we're here on what appears to be a very simple issue. Whether the lower court committed an error or abuse of its discretion when it refused to issue a preliminary injunction when there was no evidence before it that a super priority lien had ever been established. There was no evidence before the court that there was in fact a proper HOA sale where all notices were given, that there was a foreclosure of that lien properly. There was no evidence before the court
that a super priority lien had ever been established to be foreclosed upon. And there was no evidence before the court that the super priority lien had ever in fact been created. The information before the court put forth by the appellants was a trustee's deed upon sale with some recital as to the fact that an assessment was foreclosed upon. There is no evidence in the record anywhere that that assessment that was foreclosed on was in fact a super priority lien.
Ms. Hine, did you make that objection down below? Because counsel is telling us that there was no objection as to notice.
Your Honor, we have a very sparse record on our side, I will be honest. There was not a lot of discussion because when we were before the court essentially said, I don't think that you can wipe out a first deed of trust, therefore go up to the Supreme Court. I'm not going to say that everything is perfectly on the record before it, but the fact of the matter is there's no evidence of a super priority lien.
My concern is what was on the record down below so that we can put this in proper context.
The record below consisted of a declaration of the investor saying that he thought that what was foreclosed on included either 9 months of assessments or that it included expenses for the abatement of a nuisance, that therefore it was a super priority lien. There is no evidence that that was in fact the lien that was foreclosed upon. There is no evidence that there was a super priority lien ever created in this case, because in order to create a super priority lien, you have to first establish that one of the super priority lien conditions exists. That there was in fact a periodic budget for assessments created and that the lien includes those assessments. You have to establish whether it's 6 or 9 months of assessments based on whether it's a Fannie Mae or a Freddie Mac loan. You have to establish that if this is based on the abatement for the nuisance, that there was in fact a vacant property and there was a nuisance to be abated.
And were those arguments that you're now making made to the district court in opposition
No, Your Honor.
to the request?
No, I will be honest, they're not, because it wasn't available to make at that time. It was a very short brief. The judge found...
What arguments did you in fact make to the district court?
To the district court, we argued that there was in fact no notice of the super priority lien because they do not disclose it. And you cannot foreclose a lien and wipe out a property interest without providing notice of that. That notice never existed. There's no evidence that that notice of that super priority lien ever existed.
So based on the judge's decision, it appears as though it was fairly narrow. He made the assumption that a super priority lien, if she existed, could not extinguish a first security interest on the subject property.
That is
So the
correct.
issue on appeal is purely a legal question that responds to the point decided by the judge. So, would you agree with that?
I think you can say that fairly, yes, Your Honor. There's a legal question.
So your argument began, though, with the deficiency in the record, which is a deficiency that arises either by virtue of the way the judge proceeded or the way counsel proceeded, but the legal basis on which the preliminary injunction was rejected was the narrow question: does a super priority lien, if she exists, prevent foreclosure of a first security interest?
And I would argue
Why don't you argue that?
I will argue that it does not, Your Honor.
Why not?
Because you have to have notice of the super priority lien to foreclose it in order to wipe it out. And there is nothing that provides that notice.
Well, so in essence, the record in this case is wholly deficient on knowing the answer to that question.
I would not dispute that, Your Honor. The record in this case is extremely sparse.
I don't even want to suggest what I'm about to suggest, but does that compel a remand in this case so that we know whether there was a notice or not given? Counsel said you didn't raise the fact that notice was deficient. You're arguing that they didn't present the fact that they gave notice, and yet the legal question that you tendered and the judge relied upon relies on that in much, at least based on your most recent argument.
question is can a super party lien wipe out a first deed of trust? I would argue it cannot wipe out a first deed of trust because there is nothing in the statute that provides a mechanism for it to wipe out a first deed of
I
trust.
guess the other thing then is this record is deficient on how this foreclosure occurred. Do we even know from this record whether it was on the basis of a non-judicial foreclosure or a judicial? Talking about the record made to the district judge.
The record of
Not what you know.
the record made to the district judge consisted of a foreclosure deed upon sale. That is the entirety of the record.
May I ask you though, where in your brief did you, even in your brief on appeal, did you make the arguments you're now tendering? It seems to me you're stuck under shook because you argued on the grounds that as a matter of law, a non-judicial foreclosure of a homeowners association lien, A, is a payment priority, and B, in the non-judicial foreclosure setting, cannot extinguish your client's first deed of trust. I mean, that's what you engaged on, is that correct?
That is correct.
Can you cite to me where in your brief on appeal you argued that there is a factual deficiency in this record as to notice?
I cannot, Your Honor.
So you're coming here and making an argument that not only wasn't made in the district court, it wasn't made in your briefs on appeal either.
Let me redirect the argument, Your Honor.
That would be a good idea.
Thank you. The lien has been treated as a payment priority since its inception. That is the history, that is the information that we have. When we have contacted HOAs, and this is argued in the record, and requested the super priority lien, we have been told we can't have it. That the super priority lien does not in fact exist until such time as the first deed of trust forecloses. The super priority lien doesn't exist until the first trust deed forecloses. If the super priority lien doesn't exist until the first trust deed forecloses, how are we wiped out by a super priority lien? We are also told that we cannot have the super priority lien because it is a violation of FDCPA to disclose the borrower's private HOA account information to a third party who is uninterested. The legislature cleared up that in the most recent legislation, providing a provision that specifically directs the HOA to provide a lien payoff to a mortgage holder when they request it, to the tune of $150. So the purchasers are coming in here and saying, oh, you're wiped out. But the fact of the matter is what's below us on the lower court is the fact that they won't tell us. The argument we made in the lower court is you cannot interpret this statute to say that you wiped out a first deed of trust on an unknown, undisclosed amount. If you are going to wipe out a first deed of trust, the amount must be knowable. The amount must be disclosable.
How did they, when this foreclosure process is started, the private foreclosure under Chapter 116, don't they notice you and say, we're seeking to foreclose for X amount of dollars that are delinquent association fees, and notice is given that it'll be sold at a certain date, time, and location? Don't you get notice then, at least the amount, when it's going to take place?
Theoretically, there is no requirement under the statute that they provide notice. So if, for example, if an HOA is foreclosing a lien that is not an assessment lien, let's say it's nuisance violations or something else, not one of the super priority conditions, we are never subject to a 9-month super priority.
Have you considered the June 1, 2013 report of the Joint Editorial Board for the Uniform Real Property Act, which on the 6-month limited property lien? Have you had a chance to look at that?
Extensively, Your Honor.
And could you comment on footnote 9 in the text accompanying it, which refers to 2 federal district court cases that say those cases interpreting Nevada's limited priority lien rejected the reasoning of Summerhill and concluded that the association's non-judicial foreclosure of its assessment lien did not extinguish the lien of the senior mortgage holder. But they're disagreeing with that. The official body that interprets the uniform law that became our Chapter 116 with some revisions seems to be saying that the way they meant the original uniform provision to be interpreted as that it fully applies to non-judicial foreclosures. A, it's a super priority in the true sense of the word, and B, as to the 9 months, an HOA can foreclose out non-judicially the senior deeded trust holder as to, in our case, it's 9 months, but in the Model Act, it's 6. What do you make of that? Just that it's wrong?
Well, I think that there's a couple things here. First of all, it's 6 or 9 months. It's dependent. You don't know that. You have no idea what that is. The other thing is they say it's wrong, but if you look at the examples that they provided, every one of those examples says there is notice and opportunity to pay that lien that was disregarded. That is huge.
Does that counsel then an interpretation that institute an action would really be fairer if in Nevada you did it in the judicial foreclosure action setting where you would have some judicial officer determine the amount and then you would have a 1-year redemption similar to tax sales or other sales? I mean, I understand Mr. Infuso's point that these are performing services and it's unfair for one homeowner to have to subsidize everyone else. But governmentally, if you foreclose a tax lien, there's an opportunity of redemption and there's notice and it goes on and on.
I think that the requirement that it be a judicial foreclosure in order to establish the super priority lien and wipe out a first deed of trust is paramount. If in fact you look closely at this report, the report itself in every single example indicates that it is a judicial foreclosure that's going on. And in fact, if you look at the statute says that when there's a foreclosure under NRS 116.3116, you're entitled to attorney's fees as part of the judgment. You don't get attorney's fees as part of a judgment without a judicial action. That is a huge, huge issue. If you have to, in order to have a super priority lien, first figure out that one was established, then figure out the extent of it and provide notice. If you're going to wipe out in this case, this was a small one. This was a $56,000 deed of trust. The value of the property per the amicus brief was about $76,000. They purchased the property for 1/10. You're wiping out my rights, subjecting the homeowner to a deficiency judgment, depriving them of the opportunity for foreclosure prevention alternatives, and you're creating what's worse, a race to foreclosure. And HOA has zero incentive to forestall its foreclosure proceedings and just take 9 months of assessments. If you follow the NRAD decision and it says you're only entitled to 9 months of assessments, $900. What about late fees? What about interest? What about the other charges and expenses that are tacked on to that lien that they're foreclosing? They want to get paid. I want to get paid in full. They want to get paid in full. What are they going to do? They're going to foreclose, because if they can foreclose the entirety of their lien to a third-party purchaser, they're going to get paid in full, as opposed to if they wait and let us just pay the super priority.
Can I ask you one other question, because you kind of went over this one quick, and maybe I don't quite follow it. You said that there's 2 different procedures followed on a foreclosure for association dues versus other items, I assume, like fines for leaving your trash can out, your dogs run loose, or things like that. You don't get notice on that? What did you say? If there's a foreclosure for this other type of, like a fine issue?
That's the important distinction, Your Honor, is that a super priority lien is limited. It's only 9 months of assessments based on the periodic budget. It's also limited to the expenses for the abatement of a nuisance when the property is vacant and there's been an opportunity for the owner to cure that nuisance that they have failed to do so. Those are the 2 instances where you can create a super priority lien. Any other lien foreclosure by an HOA violations for leaving your car parked in front, violations for not cutting your grass. We see assessment liens that contain thousands and thousands.
What happens on those? Do they try and wipe out trust deeds for these types of foreclosures, for these fines, or what? I mean, what's going on with them?
If you've never established what part of the lien is super priority and what part is something else, how are you foreclosing? There's two liens at issue. There's the lien that consists solely of the super priority, and there's the lien that consists of everything that isn't.
So that doesn't wipe out the interests of the bank or others?
Correct.
Okay.
So if there's an HOA foreclosure and let's say the amount is $15,000 and 1,000 of that is assessments. 1,000 is assessments. Of those 1,000 in assessments, 900 is the 9 months of common area expenses based on the budget. That's $900. The rest of it is not super priority. What that would presume is if there was a foreclosure of that, they would be foreclosing on $900 that's prior to the first deed of trust. Everything else is junior to us.
This discussion is helpful in gaining an understanding of the overall problem that's presented in a number of the cases pending in the court. But I'd like to return to this case and this record.
Your Honor, in this
Case and this record doesn't include hardly any of what we've been talking about. What it does say is a very narrow question. Does the foreclosure of a super priority lien extinguish the first security interest? And in response to that question, you argue, as I understand it, that it does not, and the reason that it does not is
because there's no notice and opportunity that there was not, in fact, the institution of an action through a judicial foreclosure is required by the statute.
how do we know that from this record?
You don't, Your Honor. I cannot dispute that. This is one of the very earliest cases briefed. The briefing was very incomplete. It was done on short notice. A lot of these arguments weren't developed. So when we did the briefing on this, we have a very small, limited record. I do not think it would be inappropriate for the court to remand it back for further findings.
Counsel, do you concede, though, do you agree with Mr. Infuso that this 9 months is a super priority lien? Let's put aside judicial foreclosure or private foreclosure. Is that a super priority, which is ahead of the first deed of trust?
Yes, as a payment priority.
No, a payment priority is distinct from a super priority lien, so you just answered his question.
With the question,
Yes,
is it a true super priority lien
Yes,
so
that's-
that it could wipe out a first deed of trust?
yes,
Assuming that the lien was validly established and notice and opportunity were given, yes. I would concede that if you sent me a notice and said, I am foreclosing on $900, that is 9 months of assessments based on the periodic budget, if you don't pay it, you're wiped out, absolutely.
okay.
Thank you. Okay, Mr. Infuso.
Well, that just made it a lot easier. They just conceded that this is a true super priority lien given notice.
Mr. Mancuso, before you get into that, let's go back to the question I started this roll with, and that is, what was in the record down below?
Sure. And let me address that, because that was going to be where I was going to start off before that comment. There's a foreclosure deed in the record. It's at JA. This is the beginning of the foreclosure deed. And it provides in the foreclosure deed, which is authenticated, and it was attached to the complaint, the verified complaint, that it was a foreclosure of a notice of delinquent assessment lien pursuant to NRS 116.31162, .31163, .31164. In other words, this was a foreclosure.
And what kind of notice was given to the parties based upon that? Was that presented to the court, or do we have to assume it based upon the pleadings?
I don't think we didn't present any evidence that they received notice.
There
far as notice, the only thing that's in the record regarding notice is their failure to deny that they got it. They did not raise it. They had the opportunity in an opposition. They could have raised it. They didn't.
But you can't tell us the notice was given.
I cannot tell you that notice was given because this was the foreclosure in November of 2012. We filed the lawsuit in January 2013, and the preliminary injunction was heard just a couple weeks later. No discovery was conducted, and whether or not notice is given is not in possession of a third-party purchaser. That's information that's in possession of either the HOA or its foreclosing agent. So we didn't have opportunity.
Your argument would be that your title came to you by virtue of this foreclosure deed, and in the preliminary injunction hearing, there was no challenge to the validity of the deed.
That's correct, and we can take this one step further too, Your Honor, is that in the foreclosure deed, it contains recitals that certain things were done, that notice was given, and those are conclusive under Chapter 116. So, there's an issue of whether or not that they're conclusive. Can they be rebutted? Presumably not. But they didn't even make an attempt to challenge the conclusiveness of those
But
recitals.
at
That
this
notice was given.
stage, you were just asking for an injunction.
At this stage, we were just
So
asking.
those assertions could have been challenged had it gone to a full hearing.
The assertions of notice?
Yes.
Most certainly, but it could also have been challenged at the time of the preliminary injunction. There was certainly enough opportunity for them to present that evidence.
And your claim of error on appeal is the judge denied the preliminary injunction.
That's correct, based solely on his interpretation, though. And that's another thing I want to point out, is that the judge specifically determined in the order, which is at JA 194, specific language is on JA 197. The court holds that the Homeowners Association's foreclosure of its super priority lien under NRS Chapter 116 did not impact or extinguish the first security interest of the subject property. In other words, the court made a factual determination, not challenge on appeal, that it was a super priority lien that is composed of 9 months worth of assessment.
And the lender had the opportunity to be heard before the preliminary injunction was denied, correct?
That is correct. They filed a written opposition to it.
And in that, they did not traverse that the deed that you all had was on its face regular.
Not in any way whatsoever, Your Honor.
Okay, thank you very much, Mr. Infuso, and you might want to stick around for the next case. Maybe we'll get chapter 2 here. We'll see what the facts are here like that. Okay, and again, Justice Peregrine will participate in the decision of this case, and we will take it under submission. Thank you all for indulging us, maybe in some extraneous questions and all, but we're trying to get a handle on these issues now. Ready, we'll call the next case, which is case number 63078, SFR Investments, Pool number 1 versus U.S. Bank National Association. We have Ms. Gilbert, Ms. Klein, and Mr. Panoff on behalf of the appellants, and Mr. Stern on behalf of the respondent. So, Ms. Gilbert, you may proceed, and do you wish to reserve any time in rebuttal?
Yes, Your Honor.
Yes, to Mrs. Douglas.
Actually, I'd like to make a disclosure, although it is of ancient history. The fact of the matter is that Ms. Gilbert had served in the first year of my first term as my law clerk. That does not, in my mind, create a small-time position for me, and make that statement only for the record to be clean.
Ms. Gilbert, how many you'd like in rebuttal? I'm sorry, 3?
4 minutes.
4, thank you. And Justice Perigary will participate in the decision in this case, even though he's not present today. He'll listen to the oral arguments. With that, I think you may proceed.
Thank you, Mr. Chief Justice. May it please the court. Jacqueline Gilbert, Diana Klein, Jesse Panoff on behalf of SFR Investments Pool 1 LLC. SFR was not the HOA. SFR was not the collection company that held the foreclosure sale. SFR attended a publicly advertised, publicly held foreclosure auction and made the highest bid at that auction. It's a third-party purchaser. This auction took place 3 years after the borrower, the bank's borrower, defaulted on its association assessments and surrendered the house in bankruptcy, and left the burden, both the bank, Bank of America, and U.S. Bank, left the burden of taking care of the house to the non-defaulting homeowners that live in the association. In April 2012, the bank recorded its foreclosure mediation certificate. It still did nothing and left the association without an ability to collect its assessments. So the association decided to foreclose, and SFR obtained title to the property. Just like the last case, the district court gave the bank a pass on its inaction. The district court here differently, though, got it right on extinguishment. It had to necessarily determine that prior means prior, and that foreclosure of an association lien will extinguish a first deed of trust. What it made errors in and led to its wrong conclusion was that without doing a proper state actor analysis to even determine if due process is implied, let alone violated, it determined that there was no notice requirement to the first deed of trust holder. Because of that, it determined there was a violation of due process, again, without doing the analysis. And because it determined that there was no necessity for notice, it, in using the constitutional avoidance doctrine, said that action must mean lawsuit. It didn't need to reach that, because notices are absolutely required under the statutes. On NRS 31163 and 311635 necessarily say that the holder of a recorded security interest who has notified the association of the existence of the security interest must receive the notice of default and the notice of sale. In Nevada, a person has notified the world of its interest if it records under 111.315 and under 111.320 of the contents of the notice. Then, as was discussed earlier, is 107.090. Is incorporated into 116 in full. Justice Hardesty, the entire statute comes in. And the noticing requirements that are under 107.090 are that a junior security interest, a subordinate interest, must receive notice. And since the deed of trust is junior to at least a portion of the association's lien, which is only one lien, by the way, then the association has an affirmative duty to go to the recorder site, find out who's subordinate. It does that usually through a trustee's guarantee, a title guarantee, gets the information from the title company, which gives it to the trustee who's going to sell, whether it's under 107 or 116, and then the trustee who's holding the sale, the private trustee in both cases, will send out the notices.
Let me ask you this on the notice, and it's kind of a hypothetical, but it may play into what you said. Let's say the homeowner who had defaulted, not paid the association, and entered into a contract to sell the property to a third party and defaulted in that contract, and the third party is sued for specific performance and recorded a lis pendens against the property. But there's a lis pendens of record. Does that person suing for specific performance with the lis pendens have a right to notice from on the sale of this property?
I believe so, Your Honor. I think anybody, when they go get the trustee's sale guarantee, the title company is going to pull anybody who has a potential interest in the property, and they're going to notice everybody. And under a hypothetical, and what we've seen in other cases, and I can't specifically talk to this case, is that the bank the taxing authority, even though it is actually superior to the homeowners association lien, has an absolute exception, receives notice. They pretty much noticed the world.
Ms. Gilbert, in the findings of fact entered by the judge in this case, there is no finding that I see where the court concluded that the notice of the HOA sale was given to the lender.
I understand, Your Honor, and she did make that finding. She believed that under, first, the bank in this
I
case,
said that I don't see a finding.
finding of fact, that notice was given,
Right.
and
Do you disagree with that?
I do disagree with that.
Which finding does the judge recite that notice of the trustee's sale was given to the lender?
No, I apologize, Your Honor, and I misspoke. The judge does not make this finding that notice was given. The judge, in this case, that the facts that were on
Was
the
there
record,
anything in the record that addressed that point?
there was in the record, similar to the last cases, the trustee's deed with the conclusive presumption that notice was done according to the law.
In paragraph 6 says the HOA reported the notice of trustee's sale on September 29th.
Correct.
That's preceded by the fact that the association apparently recorded the notice of delinquent assessment lien for $1,225.19, but it doesn't reflect that there was any notice given to the lender of the notice of delinquent assessment lien, but it also doesn't address whether the lender objected to the absence of notice. What's the record in this case?
The record in this case is that this was a motion to dismiss. SFR alleged that notice was properly given to the lender, that they had notice of it. The lender never denied that. They never made an affirmative allegation that they did not receive notice. And because it, again, was relatively early, there was no findings. SFR relied on the trustee's deed, which said the notice was given. We have the notices. Again, SFR is not in possession of that and is entitled to rely on those notices.
So the lender in this case did not challenge the procedural steps taken by the HOA that resulted in your client's trustee's sale.
I believe that in the record, and I can't point you to the exact paragraph, they may have said that the statutes don't require that they get it, but they never made an affirmative statement that they did not.
Okay. So the record, from your point of view, is deficient on any claim on the part of the lender that they didn't get notice.
Yes, Your Honor.
Okay.
Again, as we spoke, I believe that the notices that were recorded, the notice of default and the notice of sale were sent to the pursuant to statute are required to be sent, and according to the trustee's deed, met the requirements of law, so they would have received them. And that SFR, as a third-party purchaser, doesn't have to prove that one way or another. They're entitled to require. If the bank didn't receive notice, then its issue is with the trustee who held the trustee's sale, not with the third-party purchaser. It's a wrongful foreclosure. They could have filed that. They didn't. The third-party purchaser they're not required to give notice. They're not in charge of it, and they don't have the information. The district court decided that because it didn't believe the statute required the notice, it then said due process was violated if there was no judicial action. It never made the finding that there was a state act or a state action. I believe had it done that analysis, and this court will be the first time that anybody who is challenging constitutionality, because SFR does not, will find that there is no state actor, there's no reason to apply that legal fiction to a homeowners association, and there certainly was no state action. The state's not involved in any part of the process of non-judicial foreclosure, just as it isn't in a deed of trust sale.
But they did raise the issue that you have to use judicial foreclosure for this type of proceeding, and whether it's a due process violation or not. That was raised in district court, and the judge agreed with it.
No, it was raised in district court, Your Honor.
Tell us why you think the judge was wrong in saying that you have to have a judicial foreclosure here and the definition of the word action.
I believe there were two reasons. First, she only went to action because she believed there was a lack of notice. And so I don't believe that she ever needed to go there. And I think she was just trying to fix a due process issue that didn't exist. But even
That's why I
that,
posed the question. She said there's a lack of notice, but the record doesn't indicate there is a lack of notice.
correct. And so I believe that that didn't need to happen. Second, action here, as was discussed in the earlier case, is it's the institution of an action to enforce the lien. It has to be looked in context. And that phrase was lifted directly from the UCIOA. In other words, the legislature didn't say, oh, we're going to use this phrase because this means to do a lawsuit in Nevada. It lifted that phrase verbatim from the UCIOA. The UCIOA fully intended, if you look at the comments to the UCIOA, and if you look at the JEB report, that they fully intended that whatever the foreclosure process that was going to be used by the state would be whatever that institution of an action would be, and would have the same result, because we want to look for that. What's the result of foreclosure, whatever the process is? That it will be extinguishment. So there's nothing to limit institution of an action in the UCIOA. This court just recently said, let's look historically as to how this was used. The UCIOA is where it was historically used. Henry L. Judy, who was general counsel for Freddie Mac at the time that that UCA was done, the Condominium Act, wrote contemporaneously with that act that the foreclosure, preferably by sale, would result in extinguishment, and that, he said, quote, priority of the association's lien will not depend upon the nature of the chosen foreclosure remedy. Where are you quoting from? I'm sorry, Your Honor, that would be in, it's the Uniform Condominium Act. I think it's cited in our reply brief. The Nevada Real Estate Division got it right. They looked at the UCIOA. They looked at the non-judicial, what the legislature did. It gave non-judicial foreclosure as a remedy. It didn't direct you to Chapter 40.
Ms. Gilbert, I know there's about 3 minutes left. Did you want to reserve that?
I would, Your Honor.
Thank
Unless
you.
there's somebody, a specific question.
Okay, well, why don't we hear from Mr. Stern, and
Thank you, Your
I'm
Honor.
going to put Mr. Stern on the spot here and see if he agrees with Ms. Schuler-Heinz on the issue of the super priority for the 9 months. Does that have priority over a first deed of trust?
No, Justice Gibbons, do not agree with Ms. Schuler-Heinz on that. And we'll start with that. A lot of our argument also has to do with due process. I think we can, and I'd like to say now that that kind of presumes that there is a super priority, but we don't concede that. To the contrary, we believe the statute, in our view, plainly preserves the priority of the deed of trust. Otherwise,
You don't accept the concession that prior counsel made?
no, Justice Becker.
Okay.
We do not, and frankly, in order to accomplish the result that SFR wants here, which is to take this to wipe out this $885,000 deed of trust with its $6,000 purchase, we would have to read NRS 116.31162B completely out of the statute. If SFR is right, and if the pre-existing deed of trust is wiped out, what is that statute doing there? Subsection 2B. It says plainly the deed of trust is senior to the HOA's lien.
But it goes on to say that, however, you have to 9 months, this is a super priority on that. So how do you reconcile those two provisions?
The way we reconcile those in our brief, Justice Gibbons, and this conforms with what the industry has done for years before this became an issue, is to hold that the HOA has a lien that survives the bank's deed of trust. And when the bank forecloses its deed of trust, the super priority portion at that point attaches. And so it's not there's no doubt that there is a lien, not simply a payment priority. We don't argue that. In our view, it is a lien. It is capable of forcing a sale. The disagreement here, I think, with SFR is, when does that lien attach?
You're saying it's subordinate to the deed of trust, the first deed of trust, that lien.
Correct, Justice Gibbons. Not only it's a subordinate, it's a co-ed. It doesn't even attach until our deed of trust is foreclosed on it, so it never had an opportunity to be prior.
Well, how, sir, just sir.
Mr. Strick, the basis of your position is reliance on industry practice. That's interesting authority. I think most of us would look at UCLA, look at how UCLA was developed, the interpretation afforded to it by this most recent report, the approach taken by the Division of Real Estate. What authority do you provide to us that says that we should look to how the industry has just done it for the past 10 years?
I have no such authority, and I don't point the court to that as authority.
What is the basis for your position? I presume it's directed at statutory interpretation rules of construction.
That is correct, Justice Hardesty. It is a question
What
of...
would the analysis be from your point of view in handling the language after the flush line?
A number of doctrines, I think, come into play, Justice Hardesty. We start with the plain language, as the court, as all courts do. I think if we look at the multiplicity of opinion among the district judges and the federal judges, we may believe that the statute is ambiguous. Once a statute is ambiguous, we look at legislative history. We look at public policy. We look at other portions of the statute of both Chapter 116 and other statutes to read all of the provisions harmoniously. I'll address both. First of all, the plain language. The plain language is found in subsection 2B. It says, the bank's deed of trust is senior. There is no way to reconcile that harmoniously. Let me phrase it this way. It is not a harmonious reconciliation between that language and subsection 2C to simply say subsection 2B doesn't apply. And that is in essence, the effect of determining that the HOA lien can wipe out the bank's deed of trust.
Well, you would agree that in J.E. Dunn, we described in some length in excruciating detail the importance of the flush line in a statute and its application of the language to all of the subsections in the section. Would you agree with that?
I agree with that, Justice Hardesty. And
So what do you make of the language? Lien is also prior to all security interests described in paragraph B to the extent of any charges incurred by the association, etc., over a period of 9 months.
what we make of it, Justice Hardesty, is that it's a limited priority. It is limited in two ways. It's capped at 9 months, so there is a limit in the amount. In addition to the limit in the amount, in our view, it limits the ability of the HOA sale to wipe out the deed of trust.
And this was my question. You've argued, and I think the prior counsel argued for the lender, that this isn't a lien in the true sense of a lien, that it's a payment lien.
I do not argue that, Justice Hardesty.
You don't get that?
No. I believe that statute, plain language, it's prior and it's a lien, and we acknowledge it that it's a lien. We don't believe, however, that means that it discharges the deed of trust, because what the statute leaves unsaid, first of all, the statute doesn't say that at all. It says it's prior. It doesn't even say when it attaches. We believe that the best interpretation, going from the plain language that goes into the institution of a judicial action, is that the super priority attaches only when the bank forecloses. And again, I'm not saying, well, the HOAs have been doing it this way, and therefore that's what the law is, but it's the best reconciliation of all of the interests here. And
So if we were to interpret it in the manner you suggest, a lien which was designed, at least according to the report by the uniform law folks as to you, to provide a funding source for homeowners associations and a protection for their budgets, will be wholly dependent on what a lender ultimately decides when, if
agree that it would be wholly dependent, Justice Hardesty, it would be dependent only to the extent of 9 months.
No, you just said that the determination of the 9-month lien amount would be triggered only upon your notice of default.
I'm sorry, I understand the question.
And if that's your argument, then it would seem like this budget protecting program that was set forth in Euclid as outlined in 116 leaves the homeowners association on the whim of the lender to initiate its notice of default. Is that your argument?
No, Justice Hardesty, there is nothing stopping the HOA from doing what it did in this case, which is to foreclose. The issue is discrete. The issue is, does that foreclosure wipe out the deed of trust? And the HOA can foreclose, collect, as was the case here, a $6,000 amount of revenue, which is sufficient to meet the HOA's needs, without disturbing the seniority of the deed of trust. And this is, again, looking at the totality of the statute and the public policy and the legislative history. This satisfies everybody's interest. It satisfies the HOA's interest. They're able to foreclose. It satisfies the bank's interest and incidentally, the HOA's interest, because the HOA in this case, Southern Highlands, doesn't want to wipe out the deed. They said so in their CCNRs.
But it seems odd that the statute creates for the homeowners association two different types of liens and then provide that they're going to be foreclosed in exactly the same way. Why would the legislature create or designate a lien for certain items for 9 months and then have a lien for a whole bunch of other stuff in additional amounts after 9 months, but say that it can only foreclose in the same way as to all of it?
I believe the method of foreclosure, first of all, we agree that the method of foreclosure here should be judicial action, but assuming that we're
not even in the method of foreclosure yet, I'm just trying to figure out what's being foreclosed.
I'm sorry, I misunderstood your question. I apologize for that. There's a number of competing interests here. Two principal competing interests. One is to get the revenue to the HOA. That is satisfied by having the HOA levy assessments and foreclose as Southern Highlands did in this case. There is the competing interest, and there's the additional interest of having some of that revenue come from the bank, because it guarantees a minimum amount. And I think the legislative history we discuss here in our briefs explains that the amount went from 6 months. It was contemplated to come to 2 years because of the delays that the banks had. It came back to 9 months.
Mr. O'Flyn's testimony.
Right, and so the idea, first of all, in our view, that would not make sense at all if the HOA discharged the deed of trust. What would be the reason in requiring the bank or resetting it at 9 rather than, or even 2 years, rather than 6 months if either time the HOA can foreclose?
You made a statement about something right here, but you said everybody was happy with it because they got paid. What did SFR buy from your position? What did they buy?
They bought what they paid for it, $6,000 house. This is an $885,000 deed of trust, Your Honor.
That's what they bought?
They bought, in our view, what they bought is a property covered by the first deed of trust, and that's why they paid $6,000, not close to $1 million, which is what our deed of trust was for. So the suggestion, I think, that was made in I think it was in the reply brief, and it may be implicit in your question, Justice Douglas, is that unfair to SFR?
What's their interest, I guess? Why should they be bothered to buy anything? You're just getting a strange interest because you're saying, well, you still have this loan out there for the property. It's encumbrance, so you're saying, because you're not privy, so to speak.
We agree we're not a privity, and that's why we believe we haven't even gotten to this. There is state action agreement, but Justice Douglas, what they're getting is the use and enjoyment of the property for an undetermined amount of time until the bank forecloses. And during that, and $6,000 we would suggest is a very good price for that. And they get to collect rental income.
So then the only way that you don't foreclose if they start paying?
I don't know.
That's why I'm asking. If you don't know, how do we know?
Justice Douglas, I can't speak to whether,
I'm trying to figure out, because you said everybody was happy based on this. Obviously, everybody is not happy.
well, obviously SFR is not going to be happy if it doesn't get an $885,000 property paying only $6,000. If they don't get that, they won't be happy. I'll concede that.
Mr. Stern, why don't we maybe convert into that issue here, because the judicial foreclosure, whether that's required or not, that's an issue that's squared up in this case by Judge Al. Tell us why, and that if the Nevada legislature has enacted these private foreclosure statutes, that we shouldn't follow them and allow the private foreclosure versus mandating a judicial foreclosure outcome.
Couple of responses there. One is that's what the statute says. It says institute an action. When it doesn't say take some action, this is not a verb. It's a noun. A lawsuit. Action means lawsuit in this context. And what Ms. Schuler-Heinz quoted during her argument, that there's a provision that says that in any action where there's a judgment or decree, that presumes a judicial action. So the statute contemplates that. Now, granted, we have now NRS 107.090. We have that issue as well. Justice Gibbons, I don't disagree necessarily that, or I don't argue that it would violate due process for the HOA to foreclose non-judicially. My argument is that it would violate due process for that sale to wipe out the pre-existing deed of trust, unless there is one, a judicial action, because that's how we guarantee that there's notice, or if the notices are sufficient. And the record in this case, I believe, is more robust than the last case. And in this case, there was an issue made of the notices. And while it may not have made it expressly in Judge Al's findings of fact, U.S. Bank did argue that the notice was deficient in a number of ways. It did not say anything about a super priority lien. It didn't give us notice that it was foreclosing a super priority lien. It didn't lay out the amount. And so if you look at the notice, and we did make this argument below, the notice doesn't even tell us what the super priority amount is. And so the bank is left in a position of having, in SFR's view, to take additional measures to investigate what that amount is. That's not due process.
On the, I'm in that neighborhood, but a slightly different issue. On the June 2013 report on the Uniform Commercial Act, how do we not follow that defensively? There is the lead-in statute that when we adopt the Uniform Act, we're doing so in the hopes of following national precedent, etc., and our legislature incorporates that. Our case law says we usually then look to other cases construing the same act and official commentary to the act. We then come along and in June of 2013 get this report, and I'm not quite clear on what this report is in the norm of things that interpret official uniform laws annotated. But I didn't find any cases cited by anybody, or my own independent research didn't turn up anything that says such a report does not command the usual judicial deference that official commentary would. Do you have any observation on that point? Do you even understand what I'm talking about?
I understand the question. I do have some thoughts on it. I just want to confirm I have an extra 3 minutes.
You do the answer. Well, you don't, but you can answer the justice's question.
Okay, because I thought I saw it speak a lot. Justice Becker, while we have a Uniform Act and the body that promulgates it does get deference, this act in particular was also directed, as all uniform acts, directs the legislature to tailor the act as necessary and to our state's particular circumstances. And in our state, and this is why we make so much of the public policy, it's very, very injurious to this court's and the legislature's public policy of foreclosure alternatives, of the policy behind the one-action rule, the policy of home retention, to allow a situation like this. Now, in this case, there was a bankruptcy and all that, but in most cases, that's not the case. In most cases, the HOA can wipe out a borrower as well as the bank before the foreclosure mediation, and all of those foreclosure alternatives are even exhausted. Given Nevada's peculiar policy interest of home retention, given the superfluousness of subsection 2B. Our view is that the Nevada legislature could not have intended this result. It could not have intended for a wipeout.
And particularly because this is a post hoc commentary that wouldn't have been in place at the time they adopted the legislation as well.
I agree with that, Justice Baker, and particularly it came out at the tail end of the legislative session. But all of the public policy issues are unique to Nevada, and I doubt that the authors of this report consider the foreclosure crisis in our state and our response to it, which this court has been instrumental in. And in our view, you would do a lot of damage to that if you ruled for SFR.
Justice Gibbons.
Yeah, I think Justice Hardesty had one, then Justice Douglas.
Stern, this case is different than some others. Why is the FSR a bona fide purchaser of the Valley Ranch?
Because
they dispute that?
They bought a property having record knowledge that Southern Highlands CCNRs have a mortgage savings clause, expressly subordinating any super priority lien to the bank's lien, so they had knowledge of that. I think that negates bona fide status. In addition to that, they did not pay a commercially reasonable price. And they take us to task for not having made that argument below. We would argue that we made it without using those words, because the district judge Alf did say that the likelihood of irreparable harm if an injunction would not issue on behalf of SFR was minimal because of the minimal amount of money they paid, versus basically a balancing of hardships versus the enormous amount of the deed of trust. So given the commercial reasonableness and given the record knowledge that they had of the CCNRs and the mortgage savings clause, we submit that they're not a bona fide purchaser. Justice Douglas.
I'm going to include Justice Hardesty going one step further. Why is not the HOA a party to this? Why Ms. Gilbert basically said your remedy should be against the HOA, not SFR.
Oh, that is I think there's a lot of reluctance on the part of certainly the lending community, and I imagine maybe on the part of the investors to implead the HOAs and seek damages against them or make them a party.
They don't seem to care about you.
True, Your Honor, but that doesn't mean that we there's reasons why we may not, despite lack of love lost between the two sides. I think certainly if SFR wins this, and not only they, but all of the hundreds of properties that are issued here, they could open up some significant exposure to the HOAs, and we may make them parties. But I think part of what happened here may have been that this case again, is so old that and then came on appeal. That wasn't done in this case. It doesn't mean it's not going to happen necessarily.
Okay. Thank you so much, Mr. Stern. And Justice Gilbert, you have some additional time remaining, about 3 minutes.
Well, they raised a lot of stuff. First, Your Honors, statutory interpretation is going to begin with the plain language of the statute, not with the result that everybody seems to focus on, which is how much did SFR pay for the property, or in many of these cases. The question is, if it's so little, how come the bank didn't protect its priority by paying that little amount or even less? So it's not so much what was paid here, but what they could have done to protect their interest and chose not to, because that's a decision. The bank doesn't have to pay it. They get to choose whether to protect their priority. And here, the choice was not to.
Does SFR qualify as a BFP?
Yes, Your Honor. Qualifies as a BFP for a number of reasons. First of all, the CCNR is irrelevant to determining that because the mortgage savings clause that Mr. Stern brought up. First, since 1991, there's been the provision in 1104 that says that if something violates or is contrary to the statutes, then in the CCNRs, then it's not effective. And there is no way
that particular issue, and I was not going to get into that, it's kind of problematic because by the state taking the action to go against the CCNRs, doesn't this now make this kind of a state action, which really compels due process then? Before the due process was kind of shaky, but if you have the state compelling to wipe out CCNRs, which would have just left it as a private action, now we're into a state action by the action of that.
I don't believe so, Justice Douglas, and here's why. I believe that by adopting the use
CIOA, what the state did was say, there's so many HOAs out there, some have some provisions, some have other provisions, we're gonna regulate. Just like the state regulates 107 sales.
They can regulate, but it has implications if they do so.
And I understand that to a certain extent, because to take that tack will also say that because you have to go into the foreclosure mediation program, has the state now taken, and I don't believe it has, taken a 107 sale, which across the country, and the Ninth Circuit has said in looking at NRS 107, said that that is not a state action, that's a private action. The choice to enforce still remains. The choice to enforce the lien remains with the private actors, that is the board of the HOA. So while they can't subordinate their lien, they have the choice on whether to enforce it, and that's what we have to look at.
Well, we have a situation, but for the action of the state, we wouldn't have that based on this language, because the clause was there and would have protected, the state wipes it out, and that is a state action. So doesn't that push us into a judicial foreclosure kind of posture?
I don't believe, may I go ahead? I don't believe so, Justice Douglas. First, the CCNRs were drafted after 1991, so even putting it in, it was void from the outset. It shouldn't have even been in there. And the bank knew it. Second, still doesn't put us, due process is still being given. There's one lien, the bank knows it, they get notice. So I went through the statutes, they're required to receive the notice, they receive it. It's one lien, not two liens. The only party that's entitled to pay less than the entire amount is the bank. The bank has notice, they're saying the notice isn't enough. Under Mullane, the U.S. Supreme Court in Mullane, they have to have reasonable notice of the pendency of the action. That's the foreclosure sale. They can pick up the phone, they can use their deed of trust, they can pay the entire amount. They could have foreclosed. There's a number of actions that they can take to protect their interest. They don't need to be told the exact amount in the notice, because everybody gets the same notice. They have means to find out that from their borrower or from the HOA. That, Your Honor, we submit that SFR is entitled to it's title free and clear of the banks.
I have one question for you. Is there anything in the record whether SFR, when it purchased at this sale, usually called the trustee sale, we'll call it whatever it's called here for the association lien, was able to purchase title insurance on that? Anything in the record?
There's nothing in the record, Your Honor.
Thank you. Okay, thank you both again. Excellent arguments and briefs. Thank you all for coming here today to watch the case. We will take it under submission, and we'll be in recess to the next call.